big question in the decision of the opinion in a few weeks' time will be whether or not the court says anything about the prospective content of the internal rules, which, as I've just said, the House of Lords Scrutiny Committee would be slightly miffed about. We'll just have to wait and see. Now, I've more than used my time. Thank you for your indulgence. That was a bit of a canter and a bit of a high-level one, but I'll stop there. Thank you very much.
Thank you very much indeed for rendering what is incomprehensible to the average human being actually almost comprehensible. It was a great triumph. And I'm just going to say that the oligarchy up here decided, in the absence of the Democrats down there, that we would take questions at the end. But if there is anything in what Tim said that you actually didn't understand, and that's quite easy, even though he was being very comprehensible, we might just clarify that now, because carrying all of that information in your head through to the end of Steve and Maria's presentations might be a bit challenging. So if there's something you didn't quite catch, as opposed to something you want to ask a searching, penetrating question about, speak now or we will move on. I see we have a very, very high caliber audience. Steve, whilst you were winding your way here from wherever you've wound it, we agreed that you were going to go second, and we'd be very grateful if you did. I had already introduced you as the Professor at Essex of Everything European, which is not really doing you justice, but gives people an idea of the fact that there might possibly be lurking somewhere in European law, either legal order, something that Steve doesn't know, but I doubt it. So he's now going to talk to us a little bit about the interrelationship between the legal orders, the multiplicity of legal orders, and I say no more and hand over to him.
Thank you very much for that introduction. And I decided to not to prepare slides because I wanted to sort of follow on sort of freshly from what the other speakers had to say. And the focus of what I want to say, given that Tim has talked a lot about the agreement itself, by which the EU will accede to the ECHR, and the internal rules. I don't even know if member states have seen a draft. I think we talked 2 years ago in the German embassy, and you hadn't seen a draft then, and there's still no draft. But I agree with those 2 points. I'll add to that there are detailed explanatory notes to the accession treaty, and they go into a lot of legal detail that it's important to look at them as well. And there will probably be an amendment to the statute of the Court of Justice because it will have extra jurisdiction. It'll have to regulate how that works. So there'll be all those legal instruments at EU or ECHR level. But the focus of my presentation is going to be not about what will happen if you end up suing the EU before the ECHR, separately or together with the member state. It will be on the impact in terms of national litigation raising human rights issues. And I know that we will say more about this, I'm sure, translating some of what I say into perhaps even more practical examples and implications. So Tim mentioned there's an issue of external relations competence here. That is an interesting issue about EU's external powers. It raises some abstract questions, but it also raises some very practical ones about how you use the EU's external treaties in national courts. And the ECHR, when and if the EU signs up to it, will be the most significant international treaty which the European Union would ever, I'm sure, forever, certainly up to date, have signed up to. And so its application in national courts is a very significant issue. And the point is that the ECHR, via the means of EU law, might have a stronger effect in national courts for national litigation than you'd have if you just looked at the Human Rights Act in this country. And of course, it will certainly have a stronger effect than any evisceration that might happen to the Human Rights Act after the next election. So what does that actually mean? Well, we can't be sure yet exactly what legal effect it will have in the national courts, but I'll raise the issues. And the Court of Justice probably won't rule too much on this on December the 18th, because it will be thinking more about issues like autonomy of the EU legal order and so on. We'll probably shed a little bit of light on this issue, but it will be for the litigation at national level ultimately to flesh out these issues. But fleshed out they will certainly have to be. So the first question is really a combined, two issues combined. It's the scope of the EU's accession to the ECHR and the jurisdiction of the Court of Justice to interpret the ECHR. And what do I mean by that? I mean that from an external relations point of view, the EU will be a party to the ECHR alongside its member states. That's not terribly unusual. There are lots of treaties like that. The Law of the Sea Convention, for instance, the World Trade Organization, most of the EU's free trade agreements up to date, and in the future probably with the USA and Canada, etc., are mixed agreements, both sides being parties. Loads of environmental treaties, many other treaties besides, are mixed agreements. It's an interesting question then. What exactly is the EU signing up to as compared to its member states? And this is always an awkward question for all these other mixed agreements. It's going to be an awkward question for the ECHR as well, because it links to the jurisdiction of the Court of Justice. I mean, usually when we have a mixed agreement, the Court of Justice, when it's asked, takes a fairly broad approach to its jurisdiction. It says it might even have jurisdiction to interpret that treaty on references from national courts. Jurisdiction to interpret the treaty above and beyond what the EU has signed up to. So it can interpret the treaty that's mixed if there's any clause which might affect the EU law, even if there isn't actually an EU law question in that case. So to give you an example of what that means in practice, there's leading case is a case called Christian Dior, decided in about 2000, and that's involved both design rights and scaffolding, in scaffolding, plus I think also design rights in ties, Christian Dior products. At that point, the EU had no law, it wasn't yet applicable, the EU's law on design rights. So there was no EU law on design rights. So how could the Court of Justice interpret the TRIPS, which is part of the World Trade Organization, if there's a dispute about design rights? Well, the Court of Justice said, we will interpret this dispute, the TRIPS, in this dispute about design rights, because it's about enforcement of intellectual property. And even though the EU at the time has nothing to do with design rights, it has a trademark regulation. And the TRIPS rule on enforcement of intellectual property might be relevant in another hypothetical case about the EU trademark regulation, even though this case is about design rights. So the Court of Justice has traditionally found a way to give itself jurisdiction to interpret mixed agreements where any provision of the mixed agreements could, in any other case, be relevant to EU law. What does that mean in practice? It means, it seems to me, if we follow this logic, once the EU signs up to the ECHR, the Court of Justice has jurisdiction to interpret the ECHR in any case. Because any case, let's say, relating to detention under Article 5 of the ECHR, even if there's nothing to do with EU law in that case, of course, EU law in another case could touch on Article 5 of the ECHR because we have EU rules on immigration detention and asylum detention. And equally, fair trial. EU has some criminal suspects' rights legislation. It protects the fair trial in various contexts of consumer law and other implementation of EU law. So that must mean that Article 6 of the ECHR could be relevant to some EU cases. Therefore, the Court of Justice has jurisdiction to interpret in any case involving Article 6, even without a link to EU law. So that's the starting point. Which would mean that all of the litigation that goes through any of the national courts, which raises an ECHR issue, could be referred to the Court of Justice. Now, that would be an enormous burden for the Court of Justice to deal with. And in fact, I put this to one of their judges a year or two ago. Well, are you really going to follow your case law? And he said, well, I don't know why yet, but we were not going to follow that case law because that would kill us, dealing with 22 languages rather than 2 in Strasbourg and so on. They don't want any significant proportion of the tens of thousands of cases that go to Strasbourg getting referred to Luxembourg instead at an earlier stage through the preliminary ruling procedure. So at some that's there's some legal realism for you there. What the courts, how the courts actually make decisions. But what does that actually mean? Where is the dividing line? When will the Court of Justice say it does or doesn't have jurisdiction to interpret the ECHR? Even if it's not in every case, where is the dividing line going to be? Will it simply be where there's a link with EU law? And what will that actually mean in practice? If you look at the case law on the EU Charter, it only applies where there's a link with EU law, but the practical application of that case law is, I think, confused and confusing. It's quite hard to predict. Was it easy cases, yes or no? But it is quite hard to predict. There's a lot of grey area where it's quite hard to predict whether the Charter applies or not. So do we have the same test for the ECHR? Whether the EU court has jurisdiction over it or not? If we do have a different test, what is it? And even if it is the same test, exactly where is the dividing line is going to be a crucially important issue for those of you arguing about ECHR application in the national legal system. So that's my first question, the scope and jurisdiction of the Court of Justice. It relates to the other questions. The second one being the legal effect of the European Convention of Human Rights in the EU legal system. And inevitably, that means also the legal effect in national law implementing European Union law. Now, traditionally, treaties which the EU signs up to can potentially have direct effect. It's the normal process that you go through to determine whether a particular clause has direct effect. You look at whether it's clear, precise, and unconditional. So the treaty with Turkey, to the extent it deals with immigration issues, and a number of other treaties, immigration issues, and some movement of goods issues, the Court of Justice has said on occasion that the rules have direct effect. So it is potential. In some cases, it does. The treaties don't have direct effect. The EU Court said the whole Law of the Sea Convention doesn't have direct effect. And surprisingly, and most importantly, earlier this year, it said that the UN Disability Convention, which the EU has signed up to, it's already a human rights treaty it's signed up to, that does not, in principle, have direct effect. Even the non-discrimination clause, which I think clearly does meet the criteria, the Court of Justice characterised that as a treaty among states, not really intended to give rights to individuals, oddly enough, I think. So the question is whether it might follow that, or what would be the legal effect of the ECHR. Because if its provisions are directly effective, of course, you can invoke them in national courts to set aside national legislation. You can also ask the Court of Justice to set aside EU legislation that violates the ECHR as well. So it's a strong legal effect, and it might be a stronger legal effect than under the Human Rights Act, because remember, every national court can send questions to the Court of Justice, and the Court of Justice has said that any national court must be able to set aside national law that is in breach of EU law, including the Charter and including international treaties which the EU has signed up to. So if the ECHR has direct effect, it must have the same effect, that any national court could set aside national law. So in two respects, of course, that's clearly stronger than the Human Rights Act. It's not a declaration of incompatibility. It is setting aside an act of parliament if necessary, as well as lesser types of legal acts. But certainly you can set aside an act of parliament by this means. And secondly, of course, any national court can do it. It's not just the higher, under the Human Rights Act, where the higher courts can issue a declaration. So it's a stronger legal effect even before the Human Rights Act gets disemboweled or defenestrated or whatever happens to it, might happen to it after the next election. If that does happen, of course, then the EU ratification of the ECHR would be enormously different from what we have in our national law. Now that brings me neatly to my third point, which is the legal effect of the rulings of the European Court of Human Rights. And the Court of Justice has said since about 2002 that it feels that EU law ought to take account of the rulings of the European Court of Human Rights. Of course, essentially that's the same rule as is written into the Human Rights Act, but it's at EU level, it's the Court of Justice that came up with it. There's no statute. Maybe the draft internal rules we've mentioned will say something like that in a statutory form, but certainly nothing exists now to create such a rule. It's jurisprudential. It's the Court of Justice, even though the EU hasn't signed up to it, ECHR, and doesn't have the equivalent of a Human Rights Act, unless we look at the Charter, of course, came along later, then the legal effects of the rulings of the European Court of Human Rights are something which the EU Court created by itself. And I think if you look at the case law, traditionally the EU Court of Justice is more reluctant, at least, than our national courts to depart, at least to expressly depart from rulings of the European Court of Human Rights. So, of course, the phrase "to take account" does not mean you're fully obliged by those rulings, but so that's why we have departures in our national system. The Court of Justice is a little bit more reluctant to take that view. But again, the judgment coming on December 18th, the Court of Justice is bound to say something about the autonomy of EU law. To what extent it's compromised by signing up to the ECHR, and this might give us some indication of what the role of the European Court of Human Rights judgments will be in EU law. And of course, there's two different types of issues. There's what happens if the EU is a party and loses the case. What's the consequence of that above and beyond the costs and damages order that would result usually from the Strasbourg Court's ruling? What's the consequence of that in EU law? And then more broadly, what account do you take of the rather bigger number of cases in which, of course, the EU would not be a party? I mean, maybe not even a member state is a party, but they might be relevant by analogy to an issue which the national courts and the Court of Justice has to deal with. So I think that will be a fresh issue that we have to come back to. On the question of legal effect, I mean, the Court of Justice has said that as things stand now, the EU is not bound by the ECHR. You can't rely on it as such in national proceedings. But that has to be revised. And surely the question of taking into account the rulings of the Strasbourg Court would have to be reviewed. It'll be at least as strong and perhaps even a stronger effect after accession to the ECHR. And that even though the concept of taking into account under EU law is in principle the same as the concept that's written into the Human Rights Act, as I said, without really systematizing this, it does seem that the Court of Justice is more willing to follow the ECHR, or at least if it doesn't, it's reluctant to say that it's not. So taking into account, therefore, in a particular case, might mean something different where an EU law issue is involved than where a purely national law issue under the Human Rights Act is involved. And it will certainly, again, mean something different if the Human Rights Act is amended, scrapped, and there are concerted attempts, as the Conservative Party has suggested, to limit the impact of judgments of the European Court of Human Rights in particular on our national legal system. Whatever effect that might have domestically, it wouldn't have that effect, I'm sure. It wouldn't have that effect where an EU law issue was involved, because that would go way back from what the Court of Justice has said already in respect of the legal effects of rulings of the European Court of Human Rights. So those are my main 3 points, but just a final point then about, which I've touched on already really, about what happens if the UK tries to limit the legal effect of the Human Rights Court rulings, or even to withdraw from the ECHR in the way that the Conservative Party paper suggests, that we're going to sort of bait them, ask Strasbourg to approve, and if they don't, we'll leave. Technically, there's no official legal requirement for each member state to sign up to the ECHR. But since the ECHR is a founding basis of the EU's general principles of law, since it's referred to in the EU Charter as the source of many of the rights in the Charter for compatible interpretation, it would, at the very least, be difficult for a member state to totally escape the impact of the ECHR. As long as it was still an EU member state, it would be significantly influenced by the ECHR and by the Strasbourg Court rulings wherever there's an EU law issue involved. And furthermore, even withdrawing from the ECHR, even if it's not officially banned by the EU treaties, would have limited effect to the extent that EU law is involved, because you would be able to rely on it as long as, of course, the EU is a party to the ECHR, and certainly you could rely on it even now, even without the EU being a party. You can rely on it filtered through the Charter and filtered through the general principles of EU law. The ECHR and the case law of Strasbourg already has some impact within the scope of EU law. It's probably going to be a stronger impact after accession if that happens, but there's already some impact. So even if there's no implied ban on a member state leaving the ECHR and or weakening the jurisdiction in effect of Strasbourg court rulings, and there might be, I think you could derive an implied ban on that, and then the question is, what are the consequences? What do you do to that member state that's done these things? So even if there isn't an implied ban on it, nevertheless, it's a limited strategy as far as EU law is involved. So you'd have to look even more than you do now, much more than you do now, at each individual case to see if there's an EU law link, in which case you could rely already on the Charter and the general principles, and in future on the EU's participation in the ECHR to give effect to ECHR rules in a way which it would be unable to, certainly post-Human Rights Act, a much stronger way than it's able to do so in national law. But hopefully that's useful, and hopefully I haven't taken away everything that Marie is about to talk to you about. Thanks so much.
Thank you very much indeed, Steve. I think that the metaphor, not your building metaphor, but the metaphor that came to my mind as you were speaking is that we're going to have to be walking through one of those halls of mirrors that you have at fun fairs. Now you see it's ECH, now you see it's EU, now it's EU reflected and double reflected in ECHR. And I think we're all going to need very steady and sober feet to find our way through this jurisprudentially. But fortunately, there are practitioners. And we're now going to hear from the practitioner's perspective what the practitioner of EU and ECHR sees as the possible implications for our daily practice, or perhaps our weekly or monthly or biennial practice in litigating these complex points, always supposing that the obstacle race that Tim has spelt out is eventually completed. Marie.
Thank you. Well, I suppose the first thing to say is that it's likely to be quite a minefield, and it's difficult to make precise predictions now before we know exactly how it's going to work and exactly what the rules are as to what the practical implications are. But I think that really there are going to be three main practical consequences from the point of view of individuals or practitioners who are working in the field. The first is, of course, that there'll be new grounds of substantive challenge in respect of EU legislation or EU measures. That's, of course, to the extent that the ECHR is different to the EU Charter of Fundamental Rights, because, of course, currently we can challenge EU measures on the basis that they conflict with the Charter. And many of the rights in the Charter reflect those in the Convention, and the explanatory notes to the Charter say that those rights which do reflect those in the Convention are to be interpreted in a very similar way. But to the extent that the ECHR lays down different rights or is interpreted differently by the Strasbourg court, then potentially accession will give rise to new grounds of challenge. Secondly, there'll be a further tier of review, namely by the Strasbourg court. And thirdly, I think it's going to have an impact on the case law, because I think it will probably promote greater convergence between the Charter of Fundamental Rights and the ECHR. Now, what's the current position? So the current position is that there's very limited ability to challenge EU measures before the Strasbourg court, which is, of course, why accession is meant to be happening. It's not completely impossible, but judicial review is indirect and is limited to particular types of case, namely and broadly cases in which it can be said that there's been some type of intervention by the member states. So the Bosphorus against Ireland case is the famous case, and that concerned the impoundment of a Yugoslav, so this is going back some years, Yugoslav aircraft by the Irish authorities. And they had to impound the aircraft because that was compelled by an EU regulation. And the argument was before the Strasbourg court was whether that constituted a breach of Article 1 of Protocol Number 1. And the preliminary question was whether this issue was justiciable at all, because the impoundment took place pursuant to a EU regulation, and of course the EU has not acceded to the convention. But the court, what the court held was that the question that there's a presumption that the system of EU law complies with the Convention on Human Rights, and that a member state, if EU legislation permits something, then a member state is compliant with the Convention. But importantly, the court said that that presumption is rebuttable if the protection is manifestly deficient. And so there are some circumstances in which member states can be put in the firing line for measures